Well, good afternoon, everybody, and welcome to this, I think it's the 7th in our series of adjudication case updates. Matt Grellier and I will be doing the presentation. Matt is a solicitor and the head of construction law at Kuits Solicitors. I'm a senior consultant and construction lawyer with Slater Heelis. Once more, we are grateful to CICES and every one of you for the opportunity to present this webinar, which I hope you'll find interesting. Excuse me. Detailed case summaries will be available to all members via Heather McGinty after the webinar, and there will be a recording, or there is a recording webinar, which will be available on the CICES YouTube channel following the broadcast. If you have any questions about any of the cases that we cover today, or indeed any other topics, feel free to fire off an email to either Matt or to me. We'll do our best to help you. As always, now familiar no doubt to most of you, the Act, when I refer to the Act, it means the Housing Grants Construction and Regeneration Act of 1996, Part 2, as amended by LDEDCA of 2009, Part 8. The Act applies to England and Wales, and with variations it applies to Scotland and Northern Ireland. And as you know, it introduced minimum payment requirements and a right to refer any dispute to adjudication at any time. And regulations made under the Act in 1998 and 2011 contain schemes which give effect to the adjudication and payment provisions. Today we're going to be covering 3 cases each, and the topics will be what happens if the adjudicator fails to deal with every line of defence in his decision, the commencement of a true value adjudication before payment of the notified sum, what happens if there is an overwhelming, what happens if there is an overwhelming amount of material or even a lack of time for the responding party or even the adjudicator to deal with the adjudication. A case on set off after the against the adjudicator's decision. There aren't many of these, so it's an interesting one. There is a payment sequel to that case, and then finally there is a case which deals with a number of topics, but interestingly deals with payment and pay less notices. So I'm going to hand over to Matt now, who will start us off in the Court of Session, Outer House in Scotland. Over to you, Matt.
Thanks, Ken. Good afternoon, everyone. Apologies, there is a slight delay on my audio, so if there's a bit of a delay between me picking up from Ken, that'll be why. So apologise for that if that happens during the course of this webinar. As Ken mentioned, first case up is a judgment of Lord Sanderson in the Scottish Court of Session. It's AGB Scotland and Darren McDermott. And the case involved the question of whether there had been a failure by the adjudicator to exhaust his jurisdiction by not expressly considering a line of defence. AGB were employed to carry out alterations and an extension at Mr. McDermott's home. AGB issued an interim payment application for circa 367,000 to the QS. I'll refer to that interim payment application from now on as the IPA. Upon being notified that the QS was no longer instructed by Mr. McDermott, AGB then resubmitted the IPA to the contract administrator, who issued a pay less notice stating that nothing was due. I'll refer to the contract administrator going forward as the CA. The IPA referred to, and AGB said it enclosed, a copy of an earlier letter and appendix, which set out the basis on which the interim payment was calculated. AGB commenced adjudication proceedings in which the adjudicator had to decide several issues, including whether the appendix was sent with the IPA. The adjudicator found for AGB and awarded them the sum claimed. In proceedings to enforce the decision, Mr. McDermott contended that the adjudicator had failed to exhaust his jurisdiction by failing to consider and make a finding on the defence that the appendix had not formed part of the IPA, and that the basis upon which the sum stated as due had been calculated had not been properly set out. The adjudicator had noted in the decision that Mr. McDermott had argued that AGB had not provided a basis for the calculation of the sum claimed, but had not noted the specific ground was the absence of the appendix. After reviewing the law as to the principles of enforcement, the court noted an adjudicator could not rely on a general assertion that he or she had considered all submissions and documents. There must be some effort to address the lines of defence advanced and to explain the basis upon which they were accepted or rejected, failing which the decision would be unenforceable. Mr. McDermott contended that the only questions the adjudicator had directly addressed were A, whether an earlier document could be incorporated by reference in an IPA, and whether the letter and appendix in question provided sufficient detail. GB said that it was clear from the terms of the decision that the question had been adequately addressed. They also argued that the decision should be enforced unless there was a failure to exhaust jurisdiction in a material respect, and that the court should only intervene in the plainest of cases. The court quoted various paragraphs from the adjudicator's decision, which could only be read as deciding that the letter and appendix had been included in the IPA, or at least in the earlier application to the QS. Whether that could be criticised as an ill-founded conclusion in law or fact was of no consequence. The appendix itself was already in the hands of Mr. McDermott's agents and was both referenced in the IPA and contained adequate specification. The court therefore found in favour of AGB. By way of comment, the court's approach in this Scottish case mirrors the English authorities, which is that the court will be slow to refuse enforcement. It's common, if not universal, for adjudicators to say they have read and considered and taken account of all notices, submissions and documents placed before them. These kind of statements are unobjectionable, but the adjudicator must go further and attempt to show that they've addressed all lines of defence and explain why they have accepted or rejected them. I'm going to hand over now to Ken for the next case. Ken, over to you.
Thank you, Matt. The next case deals with the commencement of a true value adjudication before payment of the notified sum. And this is the case of Henry Construction Projects Limited and Alufix UK Limited. And this was decided by a district judge sitting in the High Court, and that's District Judge Baldwin. And notwithstanding that it's not a High Court judge or one of our more familiar judges, it's a very important decision. What happened was that Henry were applying for summary judgment to enforce a true value adjudication decision of Mr. Matt Malloy, and that was dated March of 2023, awarding them £191,000 and interest. Alufix resisted the enforcement, saying that Mr. Malloy had no jurisdiction because the true value adjudication had been commenced prior to Henry having paid them the notified sum due under a payment application pursuant to the JCT contract between the parties. The sequence of events was as follows. Alufix made its payment application. Henry failed to pay, and they failed to issue a payment notice, though they served what they said was a pay less notice. Alufix commenced an adjudication based on the fact that there was no payment notice and they said no pay less notice, so it was a smash and grab, and that was before the adjudicator, Mr. Rayner. At that point, Henry, without making payment, commenced their own true value adjudication. Alufix asked Mr. Malloy, the second adjudicator, to resign. Mr. Malloy said, I've got jurisdiction because at the moment, Mr. Rayner has not made a decision, and it remains to be seen, doesn't it, whether or not the payment application is valid and whether or not there's a pay less notice. So it can be said at the moment there's a genuine dispute as to whether or not the sum is due. Mr. Malloy, quite a clever move, stayed the true value adjudication pending the outcome, and later, when payment had been ordered by Mr. Rayner, Henry paid Alufix the sum that Mr. Rayner found was due. Mr. Malloy then proceeded with the true value adjudication and found in favour of Henry. So the issue before the court was this: could a paying party commence a true value adjudication where the question of its liability to make payment claimed was genuinely disputed, and there'd yet to be a decision in a smash and grab adjudication? And the court referred to various decisions. We needn't go into them, but they were Bexheat and Essex Services, a decision of Mrs. Justice O'Farrell, a decision of Lord Justice Jackson in Grove and ST in the Court of Appeal in 2018, and the decision of Stuart Smith, J, as he then was, in Davenport and Greer. The principles then to be derived were as follows. Where a valid payment application was made and there was no payment notice from the paying party, no pay less notice given, the payer was obliged to pay the notified sum by the final date for payment, as set out in section 111 of the Act. If payment was not made by the payer, then the payee was entitled to seek an adjudication in its favour, and this gave rise to these a series of cases known as smash and grab. And then finally, where a party was required to pay the notified sum because it had failed to issue a payment or pay less notice, it was entitled to embark on a true value adjudication, as it were, to put matters right, but only after it had complied with its immediate payment obligation in section 111 of the Act. Now, Henry's case was, well, we're in a different situation here because there hasn't been a decision, there hasn't been a smash and grab decision at the moment. All that's happened there was that there was an adjudication pending. So we were perfectly entitled, they argued, to commence our true value adjudication and wait and see the outcome. And the payment obligation only became an immediate payment obligation pursuant to section 111 once Mr. Rayner had found there was no valid pay less notice and ordered them to pay the sum. And they relied on what had been said in Harding and Pace, in the case of Davenport, referring to Harding and Pace, a decision of the Court of Appeal, where it was argued, or at least the door was left open, that it wasn't an essential prerequisite to commencing a true value that you had made payment at the time of the commencement. Alufix said, well, look, the authorities are clear, you can't commence a true value adjudication, let alone proceed with it, until the existing liability has been discharged. But the District Judge Baldwin said, well, the question that I've got to answer is, what is the date of the immediate payment obligation? Is it section, is it the issue of the payment, the final date for payment having passed in relation to a payment application pursuant to section 111? Or if there's a genuine dispute as to whether or not payment is due, is it when there is a decision of the adjudicator as to whether or not that payment is actually due? And the court unsurprisingly found that the immediate payment obligation arose under section 111(1) of the Act, and that the notified sum had to be paid by the final date for payment. And that was pursuant to the case of Bexey, the decision of O'Farrell J, and indeed is what Mr. Rayner decided in the smash and grab adjudication. The existence of a genuine dispute as to whether an immediate payment obligation had arisen could not alter the position because that would effectively undermine the right to payment and tip the balance in favour of the disputing paying party. And also it might give rise to a situation where the dispute, the court was called upon to decide whether or not the dispute was actually genuine. The payer had the means to protect itself by giving a pay less notice. And then the judge went on to say, in what circumstances, therefore, might a genuine dispute as to the existence, say, of a pay less notice entitle the payer to commence a true value adjudication before payment? Were there indeed any circumstances? And this is what he said. Overall, in my view, the outcome of this case, whilst not closing the door on a true value adjudication prior to the outcome of the smash and grab adjudication, and later relying on the outcome, ought to discourage such a course in areas of spurious smash and grab dispute, but not deter those who have a sufficient level of confidence that any dispute raised results in a finding of no immediate payment obligation having been established. In other words, if you anticipate you're going to win in the smash and grab, you don't have to pay before you start your true value. But if you think you might lose, then you've got to wait. Is that a cop-out? It seems the door is still not completely closed, but it's getting closer to being closed than it was before. I would suggest that having to commencing a true value adjudication before the smash and grab outcome is probably not worthwhile in many cases, because if you win at the smash and grab stage because you've successfully argued there's no payment obligation because the payment notice doesn't work or the application's not valid, or you've served a valid pay less notice, then there is no sum to be paid. So a true value adjudication isn't immediately necessary. Whereas if you lose, unfortunately, a true value adjudication won't help you. However, the Act the Act continues to give rise to points for debate, and we'll see what the outcome might be on another occasion. So back to you, Matt, and going to deal with a case on natural justice.
Yes. Next case up is Home Group Limited and MPS Housing Limited, a TCC judgment of Mr. Justice Constable. And as Ken mentioned, it's a case which concerns the rules regarding natural justice relating to the amount of material submitted in an adjudication and the amount of time to consider it. Home Group applied to enforce the decision of Mr. Derek Pye, awarding them some £6.5 million in what was the second of two adjudications between the parties. In the first adjudication, it was held that MPS had wrongfully determined a contract under which they had engaged Home Group to perform property maintenance repair work. The second adjudication concerned assessment of the termination losses. MPS opposed enforcement on the grounds of breach of the rules of natural justice on the basis of A, the sheer volume of material comprising the referral, coupled with B, Home Group's unreasonable refusal to provide MPS with data or access to the underlying documents until the last moment, and C, a lack of sufficient time for MPA and its experts to interrogate and fairly respond to the referral. Regarding the volume of materials, MPS said that if the electronic data supporting the referral was reduced to paper, it filled 32 standard boxes. Home Group pointed out that the hard copy documents delivered to the adjudicator filled 7 boxes, but the court held that irrespective of whether the correct number was 7 boxes or 32 boxes, the quantity of information of itself did not present a valid basis for challenging enforcement. Regarding access to data, Home Group's offer of access to its data before the adjudication was conditional upon agreement to a sampling exercise. And the court said that had MPS reserved its position as to the nature and extent of the sampling, but requested access, it would have been difficult for Home Group to have refused, or had it refused, the complaint would then have had substance. Regarding time to respond, MPS and its experts would have had sufficient time to respond if they'd acted immediately instead of complaining at the lack of time and losing 3 weeks in tactical manoeuvring. The court noted that the adjudicator was able to address the issues by undertaking a sampling exercise, and MPS did in fact make considerable inroads into the quantum of the claim, which was originally in excess of 8 million. So in reviewing the considerable body of case law on the subject, the court concluded that adjudication decisions must be enforced even if they contained errors of procedure, fact or law. A decision would not be enforced if it was reached in breach of natural justice and the breach was material, i.e. it led to a material difference in the outcome. Complexity and constraint of time to respond were inherent in the adjudication process, and no bar to enforcement, no bar in themselves to enforcement. In cases involving significant amounts of data, an adjudicator was entitled to proceed by way of spot checks and or sampling. How this should be carried out was a matter of substantive determination by the adjudicator. And an error in approach, in the absence of some particular and material related transgression of natural justice, would not give rise to a challenge. The decision was enforced. I'm now going to pass back over to Ken for a TCC decision of judgment of Justice Joanna Smith.
Thank you, Matt. Well, this case is about a set-off against an adjudicator's decision, which, as we probably all know, is very rarely allowed, but could this case be one of the exceptions? The parties were FK Construction and ISG Retail, and it was a case, as Matt has mentioned before, the Dame Joanna Smith. When this case came before the court, there'd been 7 adjudications between the parties, and those arose under 2 projects. One was known as Project Barbary, and the other was Project Triathlon. And in those adjudications, in respect of those 2 projects, ISG had engaged FK Construction on similar bespoke contracts. Worth noting there that we've got 2 contracts, 2 different projects, over which these various disputes were scattered. On Project Barbary, there was the Wood decision, i.e. a decision of Mr. Wood in February 2023, and he decided that ISG should pay FK Construction just under 1.7 million because there was no valid payless notice in response to a payment application. That was followed by the Malloy decision, so a decision of Mr. Malloy in April, in which he decided that the gross value of those same subcontract works in Project Barbary was £3.7 million, of which ISG had already paid around 2.8 million. So the only balance that was due was ostensibly £900,000 to FK Construction. So considerably less due to them than the 1.7 million. And then on Project Triathlon, there'd been 3 decisions dealing with various claims, together called the Triathlon decisions. And the net effect was that FK owed ISG some £67,000. If you net all that off, what it meant was that instead of ISG owing 1.7 million, they owed £833,000 in the round. And these proceedings were brought by FK Construction to enforce the Wood decision, i.e. they wanted the £1.7 million. And crucially, no proceedings were commenced by ISG Retail or indeed by FKC to enforce any of the other decisions. Now, ISG did not challenge the validity of the Wood decision. They couldn't. But they argued the court should use its discretion to set off the sums which effectively went in reduction of the Wood decision, i.e. that they should only be paying £833,000. Now, the law on this topic was recited by the court and it's fairly well established, i.e. That a party, in order to make payment under an adjudicator's decision, must pay in full without deduction or set off, because that would be contrary to the pay now, argue later policy. But this policy is, or that position is subject to 3 exceptions. The first is where there's a contractual right of set off provision that does not offend the statutory regime for immediate payment. That didn't apply here. The second exception is where it follows logically from the adjudicator's decision itself that a set-off is permitted. For instance, where it is found that an overall amount is due, but there's no order for payment. And thirdly, incidentally, that second exception did not apply here. And thirdly, in an appropriate case and at the discretion of the court, and that's a quotation, where there are 2 valid adjudication decisions involving the same parties, both of which are enforceable, and the effect of which is that monies are owed each way, by each party to the other. And that case is HS Works and Enterprise Managed Services in 2009. And that was the exception which it was argued would apply here. So the court looked at the case of HS Works. The judge in that case formulated 4 steps to be considered in determining whether or not to allow a set-off. Step 1 was to determine whether both decisions were valid. Step 2, if both decisions were valid, were they both capable of being enforced? Step 3, if both decisions are valid and enforceable, then the court should normally give effect to both, provided that separate proceedings have been brought by each party to enforce each decision. And then fourthly, the court should decide how each decision should be enforced. Now, as you will have worked out, the problem for ISG was that the various other decisions which they were seeking to set off were not before the court. There was no enforcement proceedings. So it was going to be difficult for them to argue that those decisions were both valid and enforceable because they were not there to be considered. The court was only being asked to determine the validity of Mr. Malloy's decision. So the court said we've got no discretion to permit set-off in respect of those other decisions. But suppose we're wrong about that and we should allow the set-off. Are there other reasons why we should exercise discretion in favour of allowing a set-off? These might include the fact that, in the circumstances, what the court said was no. The Wood decision didn't indicate there could be any set-off or withholding against it. And in addition to that, there was no actual payment had been found due under the Malloy decision. All he'd done was to declare what the gross value of the works would be. There was no order for payment. And then on the wider question, which might have occurred to you, could the court order a set-off when there were different projects involved? And the court said that was a point of some interest, but they declined to decide it on this occasion. Accordingly, FK Construction was entitled to summary judgment for the full amount of the Wood decision. It's £1.7 million. For what happened next, I'm going to go back to Matt.
Thanks, Ken. Yes, next case, as Ken mentioned, is a sequel to the enforcement of the Wood decision. ISG Retail Limited and FK Construction Limited judgment of Adrian Williamson KC in the TCC. So following the enforcement of the Wood decision, ISG commenced a further adjudication before Mr. Malloy, seeking a determination of the gross value of FK's works. On the 14th of April 2023, Mr. Malloy issued a decision, I'll refer to it as the Malloy decision, in which he held, so far as relevant, that the gross valuation of FK's works at 28th of February 23 was circa 3.7 million. On the same day, ISG issued the present proceedings for a declaration that FK was entitled to no more than the sum found due by the Malloy decision and repayment of any sums paid in excess of that sum, and by subsequent amendment, repayment of the sum of circa 1.7 million paid to FK by ISG on 16th of May 2023. Let's call it the Wood overpayment. ISG relied on the decision of the Supreme Court in Aspect Contracts Asbestos Limited and Higgins Construction PLC and the observations of Lord Mance. I'll read from his judgment here. In my view, it is a necessary legal consequence of the scheme implied by the 1996 Act into the parties' contractual relationship that Aspect must have a directly enforceable right to recover any overpayment to which the adjudicator's decision can be shown to have led, once there has been a final determination of the dispute. It seemed to the learned judge that where the dispute referred to an adjudicator had then been referred to the court or arbitration and a different final outcome arrived at, it must follow that any sums paid over pursuant to the decision of the adjudicator should be repaid. The temporarily binding effect of the incorrect decision must yield to the final effect of the correct judgment. The effect of the earlier judgment on the 14th of June in these proceedings was to undermine the basis on which Mr. Wood proceeded and to reverse the Wood decision, which could now be seen to be wrong. So in the result, ISG was entitled to the declaration sought and summary judgment for the repayment of the circa 1.7 million. So I'm going to hand over to Ken for our final case, an interesting one regarding final dates for payment and hybrid payment pay less notices.
Oh, thank you, Matt. Well, justice was done as we've seen. Thank you, Matt, for that. This case involved a number of points, and I'm going to deal with them in a sort of takeaway fashion, if I may. But the case is called Lidl Great Britain Limited v Closed Circuit Cooling Limited, who traded as 3CL, and I'll call them 3CL. And this was in the High Court before one of our local judges, His Honour Judge Stephen Davis, sitting as a High Court judge on the 11th of September this year. In this case, Lidl were seeking various declarations concerning the meaning of the payment provisions of a framework agreement which they entered into with 3CL. They also wanted a declaration as to the validity of 3CL's interim payment application and as to the validity of what it claimed was its own payment notice. And if these declarations were granted, they would have the effect of overturning an adjudicator's decision in 3CL's favour. 3CL, on the other hand, were applying to enforce the adjudicator's decision which they'd got. By agreement and in accordance with the Technology and Construction Court Guide and Practice, the two applications were listed to be heard together, one full day being allowed. The judge managed to find a separate full day for prior reading, and he said in his judgment that despite the excellent written submissions, the argument over the many issues had taken the full day. There wasn't time to give judgment, so he reserved judgment. And in that reserved judgment, he granted 3CL's application for summary judgment and denied Lidl's Part 8 application. And the takeaways from this case are of some importance. The first regarding the disposition of Part 8 applications. The court reminded practitioners that issues as to jurisdiction and natural justice, which were potential defences to an enforcement application, would be heard at the same time as the enforcement proceedings. But other Part 8 proceedings relating, for example, to matters allegedly wrongly decided by the adjudicator would only be heard at the same time as Part 7 enforcement if prior reading and hearing time allowed and disposal and did not deny the disposal and the right to payment or unduly delay them. And one can see the sense of that, because if a Part 8 application is going to end up kicking the ball into the long grass so that the party with the benefit of an enforceable adjudicator's award is not able to get its money, that would be unfair. It would be a denial of rights under the Housing Grants Act. The second important matter decided by this case concerned the final date for payment. And the court said, look, there is a difference in the latitude which is allowed to contracting parties under the Act between calculating the due date for payment and fixing the final date for payment. When you calculate the due date for payment, it requires an adequate payment mechanism, and it can be fixed by reference to an act or event, such as the submission of a payment application or an invoice. See section 110(1)(a) of the Act. But when it comes to the final date for payment, that must be a period certain from the due date, and that date cannot be set by an act or event, such as in this case was required by the contract, the date of an employer's inspection or the submission of an invoice. So for that, see section 110(1)(b). So that's the crucial difference, and the parties are reminded, and it clarifies the law. The final date for payment can only be set by a fixed date from the due date for payment. So it could be 2 weeks from the due date for payment or a number of days from the due date for payment. But what it can't be is by reference to the submission of an invoice or some other act or event. The third important takeaway from this case was this. In this framework agreement between the parties, Lidl and 3CL, there were additional requirements for a valid payment application. You had to include a statement of the milestones achieved. You had to provide photographs to show the stage the works had achieved. You had to provide evidence of the insurances that should have been affected, and indeed such other information as might be required by Lidl. Now, these were not, the court held, expressed to be conditions precedent to payment, so they were not prerequisites to payment, and their absence did not mean that the payment application was invalid, though it might justify Lidl in paying less than the sum claimed. There was also, in these terms, a requirement for an invoice to be accompanied by a copy of the payment application, but that was, again, not stated to be a condition precedent to payment. Then Lidl said, well, hang on a minute, when it comes to a payment application, it has to be served or received or made in accordance with the contract, and they relied on provisions for notices and other provisions for, quote, requests, unquote. And they said this payment application was neither made in response to or in compliance with either of those provisions. But the court held that they did not apply to payment applications. And then the court said, well, if we were wrong about those findings, i.e., that the additional requirements were valid, or that the requirement for an invoice to be accompanied by a copy of the payment application was indeed condition precedent to payment, or if the payment application itself ought to have been served in the same way as a notice or request, then they would have said and found that Lidl was estopped by convention, effectively by its conduct, from denying the validity of the payment application. Why? Because they had paid one previous payment application without demur, even though it did not comply with any of those requirements. Now that's interesting in itself, because most cases in which estoppel succeeds are cases where the parties have effectively ignored the requirements of the contract and made payment irrespective of what those requirements were set out to be. And this case is unusual in that there's only one previous occasion when a payment application was paid in those circumstances. And then finally, there was an argument about a no waiver clause, i.e. Lidl said, well, look at the framework agreement, it says, if we excuse effectively non-compliance by making a payment, even though it's not a compliant payment application, that doesn't mean we waive our rights, because the contract says we don't waive them. The court said, no, it doesn't apply if there's an estoppel by convention. And then finally, and again, this is quite important, it was argued that the pay less notice was in fact a payment notice. It was a notice given by Lidl or on their behalf. It was entitled pay less notice. It purported to make deductions, in this case liquidated damages, for liquidated damages, as well as for defective work, the sort of things you get in a pay less notice. And yet they wanted to argue it wasn't a pay less notice, it was a payment notice. Well, the court wouldn't have that. The alternative argument from Lidl, finally, and this gives rise to a finding which I'm not aware of elsewhere, was that, well, it was, in fact, it was a payment and the pay less notice. It was combined. It was a hybrid. Well, before the Act was amended in 2011, it would have been possible for one notice to cover both an argument as to deductions and at the same time an argument as to the correct sum due. But since the amendment in 2011, the court held you could not have a hybrid payment and pay less notice. Separate notices are required for both. Well, that's thank you from me. I'm going to hand you back to Matt. Hope you've enjoyed this, and he's going to do the close. Thank you.
Yes, just to say, thank you to the CICS, in particular Heather McGinty, for inviting us to speak today. Hope you found it useful. If you've got any queries regarding CICS membership, their fantastic CPD schedule, or how you can get more involved with the organisation, then go to the website or please do get in touch with Heather. And if you've got any queries regarding the cases that we've discussed today or any other legal issues, please do contact me or Ken. Contact details are on the slide there. Thank you.